In commerce, a single signature on a piece of paper instantly sets off an unbroken chain of legal consequences. To understand how this works under Australian law, we start with the absolute baseline of commercial agency. In this diagram, we have a principal, an agent, and a third party. The core rule is simple. The agent possesses the legal authority to act on behalf of the principal. When the agent executes a contract with the third party, the legal connection instantly bypasses the agent. The resulting liability flows directly back to the principal. But in Australian corporate law, this simple, straight-line relationship rarely survives contact with complex commercial structures. The primary commercial vehicles mutate these mechanics, completely altering who holds authority and who absorbs the resulting liability. We are going to analyze the structural mechanics of partnerships, companies, and trusts. Understanding a legal vehicle requires mapping its unique geometry of agency. The structural container you choose dictates exactly where the liability flows. First, consider a standard business partnership, governed by state partnership acts. The defining characteristic of this structure is a concept called mutual agency. Looking at this model, you can see how mutual agency operates. Every single partner in the firm is simultaneously both a principal and an agent for every other partner. Authority here is a dense, continuously active, multi-directional flow across the entire web of individuals. If one partner executes a commercial contract within the ordinary scope of the firm's business, they trigger the agency sequence for the entire group. The moment that contract is signed, the legal obligations snap back from the third party, binding all the other partners as principals. This creates joint and several liability. Joint and several liability means a claimant can pursue any single partner for the entire amount of the firm's debt, rather than just their individual proportional share. Compared to the simple linear baseline, this web offers no isolation from risk. The partnership container optimizes for shared authority, leaving every individual node fully exposed to collective liability. Moving to the regulated corporate environment under the Corporations Act 2001, the mechanics shift. In this model, the company itself acts as an independent, distinct legal person. Because of this distinct legal personality, the corporate entity acts as the sole principal in commercial transactions. Directors and executives do not act as principals. They are strictly delegated agents of the company. When a director negotiates a deal, they mathematically bind the corporate entity to a third party. Because the entity is the principal, the legal liability returns from the third party, passes entirely through the director, and terminates cleanly at the company itself. This specific mechanic shields the directors and the shareholders from personal contractual liability. Where the partnership web exposes everyone, the corporate veil centralizes the risk into a single, non-human point. The corporate structure engineers an agency firewall, allowing human agents to operate commercial machinery without absorbing the resulting legal direction. This centralized protection creates a dangerous blind spot when professionals mistakenly step out of the corporate veil and into other legal structures. A common miscalculation is treating a trust as if it has a corporate veil or distinct legal personality. Under Australian equitable law, a trust is a relationship, not an entity. As this diagram shows, the trustee is not an agent for the beneficiaries. There is absolutely no upward flow of agency from the beneficiaries to the trustee. In all commercial dealings, the trustee actually acts as the principal. When executing a contract on behalf of the trustee is contracting personally. The trustee bears the full personal liability to the third party. The trustee lacks the agency firewall of a company director. Their only structural protection is the equitable right of indemnity. The right of indemnity allows a trustee to be reimbursed from trust property for liabilities incurred in the authorized conduct of the trust. This allows the trustee to offset their personal legal liability against the assets held within the trust. If the trust assets are insufficient to cover the debt, the trustee's personal assets remain fully exposed to the third party. Treating a trustee as a delegated agent leads directly to a catastrophic miscalculation of personal risk. Side by side, the mechanical differences are stark. Let's test them by executing a commercial lease. Under a partnership, liability binds all partners jointly and severally. Under a company, the director is shielded, the entity absorbs obligations. Under a trust, the trustee absorbs personal liability directly. The exact same commercial action yields radically different liability outcomes based solely on the structural geometry. Merely memorizing case law outcomes will fail you if you do not understand these underlying mechanics. Misidentifying the active legal vehicle during negotiation compromises the entire transaction. These mechanics are an exercise in structural engineering. Structuring commercial relationships in Australia requires organizing capital while engineering exact pathways of binding legal authority.